You just secured a 7-figure settlement. Your client and your firm is thrilled. But here's what I know after years of working on high-value cases. Sometimes the biggest risk starts the moment the case ends. And if you overlook this one thing, your client could lose critical benefits, your team could be dragged into months of unpaid administrative work, and your firm's reputation could take a hit, without you even knowing why. I'm Joanna Wynes, a former trial attorney and currently a settlement consultant. I partner with law firms nationwide to turn multi-million-dollar settlements into long-term security for clients without adding one more task to your plate. Today, I'm going to show you the hidden risk in 7-figure settlements and how to eliminate it before it costs you and your client everything. Here is the truth that nobody talks about in litigation. Securing the settlement is only half the job. The other half is making sure that the outcome doesn't harm your client once the check clears. The risk looks like this. Loss of means-tested benefits like SSI and Medicaid. Funds mismanaged or depleted within months. Unplanned tax exposure on interest or investments. Compliance violations with Medicare set-aside accounts. And emotional and financial chaos that leads the client straight back into your office. This is not about bad lawyering. It's simply about a gap that exists in almost every high-value case. I wanted to tell a little story on how a win became a liability. I was working on a sexual abuse case with significant emotional distress damages. There was a $1.25 million gross settlement. The net to client after the fees and costs was $780,000. The attorney closed the file and moved on. The client, who was on Medicaid for ongoing health needs, deposited the funds into her personal account. Within 60 days, the client's Medicaid eligibility was terminated. Private health care premiums were unaffordable without the subsidy, and the out-of-pocket costs for prescriptions and mental health treatment alone hit $1,200 a month. By month 6, over half the settlement was gone, just covering medical expenses and basic living costs. The client called her attorney not to thank him, but to ask why nobody warned her how this could happen. Why does this happen? When you secure a large settlement for a client who receives means-tested benefits, several legal and compliance rules collide. There are asset caps, and they're very low. So SSI and Medicaid asset limits are typically $2,000 for an individual or $3,000 married in most states. There's immediate reporting requirements. Clients must notify agencies of financial changes within 10 days. The failure to do so can result in overpayments and penalties. 3. Non-exempt asset handling. Settlement proceeds in a personal account are fully countable even if they're earmarked for medical needs. Further, there's no automatic protection. There's no grace period. Benefits can terminate the same month excess assets are received. So what's the solution? Let's build protection into the settlement. Here's my framework for eliminating post-settlement risk before it happens. Step 1. Do an early benefits review. Identify all means-tested programs during your case preparation. Document state-specific asset and income thresholds. Step 2. Consult with the settlement planner. The settlement planner can help identify whether benefits are means-tested, provide the client with options of government benefit protection methods, coordinate the establishment of a special needs trust or pool trust where appropriate, and coordinate with plaintiff's counsel to ensure that the funds bypass personal accounts and that the trust is funded directly from counsel's office. Step 3. Compliance. The trust company will ensure distributions of funds consistent with SSA guidelines and will assist clients in reporting their trust and settlement without disturbing benefits. In the event the client is eligible for Medicare set-asides with proper administration where it is appropriate and required. Step 4. Client education and transition. Provide clear guidance on trust rules, spending, and reporting obligations. And ensure that they have a dedicated contact for benefits-related questions with somebody who is not your paralegal. Why does this matter for your firm? Without these processes in place, your award or settlement could unintentionally harm your clients. Your staff becomes de facto benefit case managers, and your name ends up getting tied to an avoidable problem. With a process in place, your clients keep their benefits, your team avoids post-settlement headaches, your reputation stays tied to successful, complete resolutions, and happy clients. A 7-figure settlement should be the start of your client's stability, not the end of it. If you would like to close cases cleanly, protect your client's benefits, and eliminate post-settlement exposure, let's talk. Click the link below to book a 20-minute call. I'll show you exactly how we preserve benefits, protect verdicts, and offload hours of post-settlement work from your team. I'm Joanna Wynes, protecting your clients and your firm every time.